This is part 51 as far as our lecture series is concerned, and we intend to deal with chapter 35, and the heading of the chapter is the irregular proceedings, and we have to start right from section 460 up to section 466 of the Criminal Procedure Code. Now, as a student of law, we have learned by this time distinction between irregularity and illegality. Irregularities can be regularized, but illegalities cannot be legalized. And it is the nature of the irregularities that has to be taken into consideration, whether that will vitiate the proceedings or whether that will not vitiate the proceedings. So now, once we start dealing with section 460, it deals with irregularities which do not vitiate proceedings, and 9 categories are enumerated as far as section 460 is concerned, which says, if any magistrate not empowered by law to do any of the following things, namely, A. to issue a search warrant under section 94, B. to order under section 155 the police to investigate an offence, C. to hold an inquest under section 176, D. to issue process under section 187 for the apprehension of a person within his local jurisdiction who has committed an offence outside the limits of such jurisdiction, E. to take cognizance of an offence under clause A or clause B of subsection 1 of section 190, F. to make over a case under subsection 2 of section 192, G. to render a pardon under section 306, H. to recall a case and try it himself under section 410, or to I. to sell property under section 458 or section 459, erroneously, in good faith, does that thing, his proceedings shall not be set aside merely on the ground of his not being so empowered. So what is the effect of the irregularity as they are enumerated? And the effect of irregularity is that these irregularities do not vitiate the proceedings as far as section 460 of the Criminal Procedure Code is concerned. So this has got reference to what? This has got reference to the sections with which we have dealt in the past or with which we shall be dealing. But as and when you deal with that section, you will have to, as I told you, while we were discussing importance of the second schedule of the Criminal Procedure Code, in order to know the details regarding the same, you must read the form number by taking into consideration the section number which is written in the bracket under the form. Similarly, what is the effect of it, for that it is necessary for you to read this chapter. So this is required to be correlated with the section with which we are dealing for the purpose of understanding provisions of the Criminal Procedure Code. With this now, section 461, which deals with irregularities which vitiate proceedings, and it says 17 categories are enumerated. It says, any magistrate not being empowered by law in this behalf does any of the following things, namely, A. attaches and sells property under section 83, B. issues a search warrant for a document, parcel or other thing in the custody of a postal or telegraph authority, C. demands security to keep the peace, D. demands security for good behavior, E. discharges a person lawfully bound to be of good behavior, F. cancels a bond to keep the peace, G. makes an order for maintenance, H. makes an order under section 133 as to a local nuisance, I. prohibits under section 143 the repetition or continuance of a public nuisance, J. makes an order under part capital C, part capital D or chapter 10. K. Takes cognizance of an offence under clause C of subsection 1 of section 190. Try. L. Tries an offender. M. Tries an offender summarily. N. Passes a sentence under section 325 on proceedings recorded by another magistrate. O. Decides an appeal. P. Calls under section 397 for proceedings. Or Q. Receives an order passed under section revises an order passed under section 446. His proceedings shall be void. So this is the effect. Whatever was not required to be done on the part of the magistrate or court, if it is done, then this proceeding shall be void as far as section 361 of the Criminal Procedure Code is concerned. Now 462 has got reference to the local or territorial jurisdiction with which you are dealt right from section 177 up to 189, and it says proceedings in wrong place, and it says no finding, sentence or order of any criminal court shall be set aside merely on the ground that the inquiry, trial or other proceedings in the course of which it was arrived at or passed took place in a wrong sessions division, district, subdivision or other local area, unless it appears that such error has in fact occasioned a failure of justice. The next section, section 463, deals with the cases where there is non-compliance with the provisions of section 164 or section 281 of the Criminal Procedure Code. And it says, if any court before which a confession or other statement of an accused person recorded or purporting to be recorded under section 164 or section 281 is tendered or has been received in evidence, finds that any of the provisions of either of such sections have not been complied with by the magistrate recording the statement, it may, notwithstanding anything contained in section 91 of the Indian Evidence Act, take evidence in regard to such non-compliance, and may, if satisfied that such non-compliance has not injured the accused in his defense on the merits and that he duly made the statement recorded, admit such statement. Subclause 2 says the provisions of this section apply to courts of appeal, reference and revision. With this now, if we read section 464, that says effect of omission to frame or absence of or error in charge, and it says, subclause 1 says, no finding, sentence or order by a court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed or on the ground of any error, omission or irregularity in charge, including any misjoinder of charges, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact occasioned thereby. Subclause 2 says, if the Court of Appeal, confirmation or revision is of opinion that the failure of justice has in fact been occasioned, it may A. In the case of an omission to frame a charge, order that a charge be framed and that the trial be recommended from the point immediately after the framing of the charge. B. In a case of an error, omission or irregularity in a charge, direct a new trial to be had upon a charge framed in whatever manner it thinks fit, provided that if the court is of the opinion that the facts of the case are such that no valid charge could be preferred against the accused in respect of the facts proved, it shall quash the conviction. So this is as far as section 464 is concerned. With this now, section 465 deals with the cases where finding or sentence when reversible by reason of error, omission or irregularity. And subclause 1 says, subject to the provisions herein before contained, no finding, sentence or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaint, summons, warrant, proclamation, order, judgment or other proceedings before or during trial or in any inquiry or other proceeding under this code, or any error or irregularity in any sanction for the prosecution, unless in the opinion of that court a failure of justice has in fact been occasioned thereby. Subclause 2 says, in determining whether any error, omission or irregularity in any proceedings under this section, or any error or irregularity in any sanction for the prosecution has occasioned a failure of justice, the court shall have regard to the fact whether the objection could and should have been raised at an earlier stage in the proceedings. With this now, the last section, section 466, as far as this chapter, namely irregular proceedings, is concerned, deals with defect of error not to make an attachment unlawful. And it says, no attachment made under this code shall be deemed unlawful, nor shall any person making the same be deemed a trespasser on account of any defect or want of form in summons, conviction, writ of attachment or other proceedings relating thereto. So this is as far as irregular proceedings are concerned. As I told you, we have to deal with this as and when we are dealing with a particular chapter. In order to understand what is the effect of it, for that it is necessary for us to take into consideration this chapter and try to find out what is the effect of irregularity as far as the provision is concerned. With this now, in the next lecture, part of our lecture series, we intend to start with chapter, that is a chapter with which you are not dealt. So we shall be dealing with chapter 26 of the Criminal Procedure Code. And this chapter deals with provisions as to offences affecting the administration of justice. And in order to understand this, we shall be dealing right from section 340 up to section 352 of the Criminal Procedure Code to understand the provisions regarding provisions as to offences affecting the administration of justice. So this is with which we shall be dealing.